So the Davis-Stirling Act says in some certain kinds of cases, you cannot file a lawsuit until you first tried to engage in ADR. Tell me what the statute says in very simple terms, and then we'll take to the next step.
Sure. We're basically talking about Civil Code Section 5930 and other related sections within that statute. And what it says basically, Mike, is if you have an action for enforcement of the governing documents and it requires injunctive relief, or it's a claim for injunctive or declaratory relief, or a writ, then ADR, pre-litigation ADR mediation is mandatory.
So if you're suing for just one or a combination of those,
correct,
and only that's you have to do ADR.
And there's another scenario too.
Well, tell me the other scenario.
And the other one is if you have one or a combination of those, right, injunctive, declaratory, or writ, coupled with a monetary claim that is below the small claims jurisdictional amount of $12,500.
Okay.
Then it's mandatory as well.
Okay. So if I'm suing for, just an example, I'm suing for declaratory relief, which is just a cause of action where you're asking the court to declare something. We won't get into it. But let's say that was the only cause of action. Because it's just for one of the three that he gave, declaratory, injunctive, or writ relief, we would have to engage in ADR prior to filing a lawsuit. Or let's say we were suing for dec relief and breach of something, and our money damages were more than or were less than $12,500.
Correct.
In that case, we would have to also
engage in ADR.
mediation. But let's say we were suing for dec relief and our damages were $50,000.
It's not mandatory.
Not mandatory. Okay.